Mr. Dornbus, and correct my pronunciation of your name?
Yes, Dornbos is correct. Thank you. Madam Mayor and City Council, thank you. I stand before you again to speak about the proposed ADU projects at 2919 and 2924 Ariba Way, which are on either side of our property. Due to egregious inaccuracies and untruths presented in the original plans of the licensed contractor and owner of these properties, these projects have been under court order TRO, city-imposed stop work orders, and are currently under a criminal complaint by the city attorney. We have spoken previously about the untruths at best and the lies at worst that were presented to the building department in order to obtain permits under the state ADU law before the city rules came into effect. But for the alarm bells that have been rung by me and several other neighbors, these projects would be full steam ahead. One of these untruths is the misrepresentations of an elevated hillside that was shown to exist on the applicant's property as well as ours. The hill doesn't exist. Recently submitted plan revisions show the need for 285 cubic yards of fill dirt to accomplish the build and create that hill. These ADU permits rely on the city's trust of the licensed contractor, but after so many untruths and misleads, and after lies to his neighbors and apparent violations of the stop work orders, how can the city reward this with the privilege of trust? As we have said many times, these projects are, as designed, represent an undue infringement on the safety and on the quality of life of my family and many other neighbors, and the loss of privacy is undeniable and without recourse once taken away. None of this would likely be an issue if this applicant was simply required to follow the same rules the rest of us must follow, including ABR reviews and reasonable setback requirements. The state of California gives local governments the right to apply building codes and other ordinances to the building of ADUs. But instead, in the face of these multiple untruths generated by this licensed contractor and the applicant is being rewarded with the ability to simply correct the misrepresented plans rather than being forced to begin again under the rules that are now in force for the rest of us. I am urging the city to exercise this right and to revoke the permits and make the applicant/licensed contractor, in this case, start over so that these intrusive and extreme ADUs can have the oversight by ABR that any project of this nature would have under the current ADU ordinance. These designs fall well outside of the state's intention for this law. I am confident of it. And this sets a precarious precedent for our city, and I urge you all to take it very, very seriously. We need your help. Thank you.
Come on back, please. You have a question? Oh, thanks. It's a question for staff. Go ahead, Ms. Sneddon.
Well, as we know, there are legal proceedings here, so we won't discuss this particular case, but so that people know, if there is over 50 CFS removed from a site, what is the procedure then for bringing that to?
We don't have planning staff here right now.
Okay.
Yeah, Madam Mayor, I'm happy to get that information back to you, but I'm not exactly sure, and I don't want to give false information in this case at all.
Thank you.